Good morning everyone. Welcome to Mohan's Teaching Corner. Today we are going to discuss about the Constitutional Law Part 2. It is a first year second sem LLB portion. Okay. So let us have a comprehensive analysis of federal structure, emergency provisions and constitutional bodies. So distribution of powers. So the backbone of Indian federalism, one is legislative powers, administrative relationship, then financial relations. So 7th schedule divided subjects into union and state and concurrent list, and administrative relations, delegations and control mechanism between center and states, financial relations, revenue sharing, grants in aid, GST implications. So the distribution of establishments, a quasi-federal structure with a strong federal bias. So let us have doctrine of colorable legislation. What cannot be done directly cannot also be done indirectly. So court examines if a legislature has a indirectly encroached upon matters beyond its jurisdiction. So the landmark cases are KC Gajapati Narayan Dev versus State of Orissa 1953. Court ruled that intent is irrelevant. Effect of legislation determines validity. So doctrine of pith and substance. When determining legislative competence in case of overlapping subjects, courts examine the true nature and character of the legislation. If core subjects matter falls within competence, incidental encroachment on another list is permitted. So judicial review, guardian of the Constitution. So constitutional basis, Article 13, 32, 131 to 136, 143, Article 226, 246. So types of reviews, review of legislative actions, review of administrative actions, review of judicial decisions. So landmark cases like Keshavananda Bharati versus State of Kerala 1973 established basic structure doctrine. So court record, a court whose acts and proceedings are preserved as evidence and reference. So for this the constitutional provisions are Supreme Court Article 129, High Court Article 215, key powers, President value of judgment, power of punishment for contempt. So constitutional bodies, these are the pillars of governance. One is Election Commission, second one is the Controller and Auditor General, then Public Service Commissions. So Election Commission. So Election Commission conducts the free and fair elections, recognized political parties and administrates the election process. Then the Controller and Auditor General, so audits the government accounts, ensures financial accountability. Third one, Public Service Commissions conduct examination and select the candidates for civil services. So these bodies maintain the checks and balance in the constitutional framework. So let us discuss about the Controller and Auditor General, that is CAG. So the constitutional position, it is established under Article 148, 6 years term or until the 65 years of age. Then it is an independent authority with the security of tenure. The functions are audit all the receipts and expenditure, reports to President or Governor. So it's a guardian of all public purse. Then Election Commission of India, it is a constitutional status established under Article 324 for superintends direction and control of elections. Then composition, it has the one chief election commissioner and two election commissioners appointed by the President of India. The functions are conducting elections, preparing electoral rolls, recognizing parties, implementing the model code of conduct. Then independent removal process of Supreme Court judges, ensuring the autonomy. So public service commission. So there are two types of public service commissions are there: union public service commission and state public service commissions. In union public service commission, established under article 315, conducts the civil service examination, advise on recruitment methods, submit the annual report to president. So the state public service commissions, one chairman and members appointed by the governor of the particular state, and the term will be 6-year term and until the age of 62. It is conducts the state civil service exams, then ensure that merit based selections. So in TN Session versus Union of India 1995, the court emphasized the independent function of such bodies to uphold constitutional governance. So emergency provisions, constitutional safeguard. So national emergency, state emergency and financial emergency. National emergency, Article 352 declares that during the war, external aggression and or armed rebellion, that particular time national emergency provisions will be used. Then state emergency, it is according to Article 356 imposed when the state's machinery fails, then that become it is called as a state emergency, also called as president's rule. Then financial emergency, Article 360 declare when the financial stability is threatened. Okay, so these provisions maintain constitutional stability during the crisis situation. So let us discuss about the national emergency. Article 352, ground for declaration with the war-like situation, external aggression, armed rebellion, previously internal disturbance also called. Then approval process, so presidential proclamation, parliamentary approval within 1 month, requires special majority. What is the effects of this national emergency? Federal structure become unitary, parliament can legislate on state subjects, then fundamental rights under Article 19 suspended, executive power extended to giving directions to the states. So post 1975 emergency, the 44th amendment added to safeguard against the misuse. Then state emergency, according to Article 356, when it can be imposed, when constitutional machinery in a state falls according to the governor's report. What is the effects? President assumes the state executive powers, state assembly suspended or dissolved, parliament makes the laws for the state. So landmark judgment here, S.R. Bommai versus Union of India 1994. Government court established the judiciary review of Article 356. Then financial emergency, Article 356, grounds and effects. So let us discuss grounds. When the financial stability or credit of India threatened, the procedure, again the president proclamation, parliamentary approval within 2 months, no time limit, continuous until it is revoked. So then what is the effects? Union can direct the state's financial matter, salaries of the officials include judges may be reduced, money bills require president's approval, financial discipline enforced. But it is never invoked in Indian history. The financial emergency as of now never invoked in Indian history. Then basic structure and doctrine, constitutional entity. So landmark judgment of Keshavananda Bharati versus State of Kerala 1973 established that Parliament cannot alter the basic structure of the Constitution. So basic features includes supremacy of Constitution, republican and democratic form of government, secular character, separation of powers, federalism and judicial review. Then here doctrine of constitutional amendability, Article 358, Article 368, Parliament power to amend the Constitution. So pre-Keshavananda era, Shankari Prasad case 1951, Sajjan Singh case 1965, Golaknath case 1967. Then post Keshavananda era, Indira Gandhi case 1975, Minerva Mills case 1980, IR Coelho case 2007. So Parliament can amend but cannot destroy the basic structure of Indian Constitution. So impeachment of judges grounds: proved misbehavior or incapacity, Article 124 under Section 4 and 217 initiation. So motion signed by the 100 Lok Sabha or 50 Rajya Sabha members. Investigation: 3 members inquiry committee formed to investigate the charges. Then parliamentary vote requires special majority in both houses, 2/3 of the members present and voting. President issue the order for removal. So the rigorous process protect the judicial independence while ensuring accountability. So writ jurisdiction, constitutional remedies, habeas corpus. So what does that mean? Produce a detained person before the court to determine lawfulness detention. Mandamas. So what is mandamas? Command public authority to perform its legal duty. Prohibition prevents the inferior court from exceeding jurisdiction. Then certiorari, quash order of inferior courts and tribunals. Quo warranto, so questions authority to hold public office. So constitutional amendments safeguarding democracy. So key amendments strengthening the constitutional governance. 42nd Amendment 1976 added socialist and secular to preamble, introduced the fundamental duties. Then 44th Amendment 1978 restricted emergency power, removed the right to property as a fundamental right. And 73rd and 74th Amendments 1992 constitutional status to local self-governance. Then 101 First Amendment 2016 introduced the GST regime, transforming the federal finance relationship. So the amendment process under Article 368 ensure that constitutional evaluation while preserving the core values. So thank you for watching. Please do subscribe and like my channel. All the best for your coming examination.